written agreement, evidence of your consent or evidence of consideration, e.g. payment, they have failed to validate. Most collectors who receive this request will never pursue the collection. If the collector persists in ignoring your request for validation, a complaint to the Federal Trade Commission may be appropriate. Just listing the address for the FTC on the second notice is likely to get positive results. Responding to offers or demand. We have an unlimited ability to contract with our fellow human beings in any way that we choose. Our choices are dependent not upon our circumstances, but only upon our knowledge and will and creative intelligence. Whether in commerce or in law or life, whenever someone demands something from us, it is an offer to contract with that one. There are only 5 ways we can respond to an offer to contract. 1. We can ignore. 2. We can argue or contest. 3. We can reject or refuse it for cause without dishonor, as long as it is an erroneous claim, and no liability is in evidence. CUCC 3501. 4. We can accept. Or 5. We can conditionally accept. Ignoring is dishonoring to the offerer and offeree. In commerce, ignoring means agreement by acquiescence. If someone sends us a bill and we ignore it, we have committed a commercial dishonor and have silently agreed that we owe it. The offerer becomes the creditor in the matter, and we become the debtor, the slave. Arguing is dishonoring to the offerer and offeree as well, no matter how righteous the claim seems to be. Ultimately, no points of view are valid absolutely, and in a light, force, and deception are relied upon by all but the saintiest of parties. The debtor will certainly become the loser in the matter. The victor's creditorship may be a crime. Honorably rejecting and the 2 ways of accepting are the only ways we can remain in honor and take full responsibility for our life and our world, and not be a debtor victim. Full acceptance is appropriate when we agree with the substance and form of the offer. Conditional acceptance is more appropriate when we are not certain and unsure about those things. All conditional acceptances are counteroffers. Sure, I'll go to town with you if you help me clean up that mess first. Or sure, I'll accept that upon proof of your claim in the form of an affidavit signed by you under penalties of perjury and under your unlimited, personal, commercial liability. Learning how to accept conditionally is fundamental to learning how to remain a creditor and be able to freely control any situation. Private versus public. It is important to know the difference between the private and the public, because we all have private and public identity.
Simple letter requesting validation of debt under the FDCPA. You have the right to ask for validity of the debt that the collection agency says you owe to them. You will need the debt validation letter in order to challenge the validity of the alleged debt. Given below is a sample debt validation letter for you to understand how to request in writing for validation of debt. Your name, your address, your city, state and zip, your phone, date, creditor's name, department, creditor's address, creditor's city, state and zip regarding account number. Dear sir or madam, this is to inform you that I recently pulled my credit report and noticed that there's a collection listing from your agency on my credit report. I have never been notified of this collection action or that load the debt. This letter is to inform you that I would like to have a verification of the debt and your ability to collect this money from me. Under the FDCPA, I have the right to request a validation of this debt. I request that you prove that I am indeed the party who is contractually obligated to pay off this debt. Please be aware that reporting any invalidated information to mayor credit bureaus may constitute defamation of character. In addition, also be aware that until you validate this debt, you cannot continue collection activities or report this information to the credit bureaus. Non-compliance with this request may place your company in serious legal trouble with the Federal Trade Commission (FTC) and other state federal agencies. Please attach copies of the following documents: agreement with your client that authorizes you to collect on this alleged debt, agreement that bears signature of the alleged debtor where he promises to pay the original creditor, complete payment history on this account, to prove that the amount you wish to collect is accurate. Sincerely,
Affidavit by verified declaration. To whom it may concern, whereas the public record is the highest evidence form, I, the undersigned, hereby create a public record in the jurisdiction of the Maine Republic in the United States of America. Plain statement of facts. Fact 1. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is something other than a collection agency for the non-federal Federal Reserve Bank, and I believe that none exists. Fact 2. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is something other than a corporation incorporated in the state of Delaware in 1933, and I believe that none exists. Fact 3. I have not seen nor been presented with any admissible evidence which demonstrate that the IRS is something other than a corporation unlawfully acting under color of law as a government agency, and I believe that none exists. Fact 4. I have not seen nor been presented with any admissible evidence which demonstrates that the IRS is not required to adhere to Title 15, Chapter 41, Subchapter B, Section 1962, and I believe that none exists. Undisputed conclusions. Title 15 U.S.C. Chapter 41 Consumer Credit Protection. Subchapter V Debt Collection Practices Section 1692 is an act of Congress designed to protect natural persons. 1692 asserts that the term consumer means any natural person obligated or allegedly obligated to pay any debt from abusive collection agency practices. The IRS is incorporated in Delaware as a collection agency for a Puerto Rico company. The Internal Revenue Tax and Audit Service, IRS, a for-profit general Delaware corporation, incorporated July 12, 1933, file number 0325-720. The IRS is not part of the United States government. Diversified Metal Products v. Tebow Company. Trust, IRS 93405 EEJL. Several other corporations involved with the IRS are also unlawfully acting under color of law as government agencies. Notice. Notice to the agent is notice to the principal. Plan. Notification of legal responsibility is the first essential of due process of law. Connolly v. General Construction Company, 269 U.S. 385, 391. Your silence stands as consent and tacit approval to this regard. If no reply is delivered within 30 days, you are agreeing to the foregoing and are legally stopped pursuant to Carmine v. Bowen, 64 A 932 1906. Silence activates estoppel. I hereby reserve the right to make amendment to this. Document as necessary in order that the truth may be ascertained and justly determined. If any living body has information that will controvert and overcome this declaration, please advise me in writing by counter-declaration and affidavit form within 30 days from receipt thereof, proving that this affidavit is substantially false. 1. The undersigned do herewith declare, state and say that I am competent by stating the matters set forth herein, and that the contents are true, correct, complete, and admissible as evidence, and not misleading by my best knowledge and belief. This document may be recorded and may be used at the discretion of its issuer under Rule 902 of the Federal Rules of Evidence, including the jurisdiction of the state of Maine and the United States of America. By my hand this day of 2012. 26 U.S.C. 6331. This section of Title 26 conveniently leaves out paragraph A, which says that IRS levies can only be made against federal government employees. Neither a lien nor a notice of levy issued by the IRS are valid absent a validating court order signed by a magistrate. If these forms have nothing but the name of IRS employees on them, they are a fraud. The IRS often deceives financial institutions and county recorders into surrendering the property of taxpayers by issuing fraudulent notice of levy or lien documents. Fraudulent notices of levy printed on IRS Form 668A-C do documents, quote portions of 26 U.S.C. 6331, but conveniently leave out paragraph, which specifically says that a levy can only occur against employees of the federal government. The clerks of employers and financial institutions who receive these levies usually have no legal training and will just surrender the money or property of the accused without asking even a single question. on the mistaken presumption that these levy or notices of levy are legitimate. They won't even verify that the levy or lien is signed by a magistrate. Oftentimes, they are threatened by the IRS with an audit or levy or seizure of their own property if they don't comply. This weak link in our property rights is at the heart of how the IRS continues to successfully collect a tax that few Americans actually owe. This unethical application of the tax laws is called violation of due process, and it is commonplace. The federal courts, however, have said that the issue of a notice of levy does not constitute a valid levy. Below is one example. A levy requires that property be brought into legal custody through seizure, actual or constructive. Levy being an absolute appropriation in law of property levied on, and mere notice of intent to levy is insufficient. United States v. Odell, 6 Seer, 1947, 160 F, 2D 304, 307. Accordingly, in re Holdsworth, D.C., New Jersey, 1953, 113 F, sub. 878, 888, United States, v. Edna Lifens, Company of Hartford, Con, D.C. Con, 1942, 146 F, sub. 30, 37, Judge Hinks observed that he could find no statute which says that a mere notice shall constitute a levy. There are cases which hold that a warrant for distraint is necessary to constitute a levy. Given, v. Kripe, 7 Seer, 1951, 187 F, 2D 225, United States, v. Odell, Supra. The Court of Appeals for the Third Circuit state in its opinion, 221 F, 2D, at page 642 these sections, 26 U.S.C. section 3690 to 3697 require a levy by a deputy collector be accompanied by warrants of distraint, issued by a judge in a legal proceeding, in Rebrocco Manufacturing Company Supra. One, failure to file and taxes owed. Filing any document with the IRS is a voluntary act that overrides your Fifth Amendment protection against witnessing against yourself, nor being deprived of life, liberty, or property without due process of law. 19. Know that there are two separate entities, the Internal Revenue and the Internal Revenue Service, working together in concert. The Internal Revenue is an agency of the government of the United States, and the Internal Revenue Service is a collection agency for the non-federal Federal Reserve Bank. So when the IRS charges someone with willful failure to file, they are actually billing the victim for an income tax that the victim may or may not actually owe. It's a presumption that needs to be quickly rebutted by the targeted victim. The victim usually tries to fight the charge using the Constitution and/or Title 26 of the Income Tax Code without ever requesting a verified assessment of the debt under Title 15 of the Fair Debt Collections Practices Act. This gives the IRS the ability to be granted a nihil dicet judgment, a no-response judgment. Silence is agreement in United States District Court against the victim, making the bill a lawful bill. 87. Or play the game. Once the bill is adjudged to be lawful, based on the presumption of a debt, the IRS gets to claim that the victim is fraudulently refusing to pay a legal debt and thereby converts the debt into a presumed criminal act. If first you ask them to verify the so-called debt under Title 15, it forces them to deal with you as the real person, not the corporate entity known as the straw man. They have no jurisdiction over you from that point on, as the real person, and you are then dealing with the IRS agent himself, and not the entire IRS corporation. Respond to the case under Title 15 of the Fair Debt Collection Practices Act, and IRS agents have no jurisdiction over you, and the judge will treat them as they are, a collection agency, and not a government entity. If you fight the case under Title 26 of the Income Tax Code, the judge will think that you're crazy, but won't tell you why, because Title 26 has nothing to do with the IRS. It's specifically for the Internal Revenue instead. 2. Tax lien list is now notice of lien list. From the June 1999 Idaho Observer. Stevens County, Wash. Alters lien language. Auditor Tax Lien List becomes Notice of Lien List Colville on March 30th, 1999. Jim Shaver and a group of constitutionally concerned Stephen County residents presented testimony before the county's Board of Commissioners in an effort to change the language of the county's list of more than 2,000 IRS liens. The Stevens County Commissioners responded May 11, 1999, by advising Shaver by letter that the board and the auditor have read the materials you submitted and consulted with the county's legal advisor. It is our joint decision to change the current tax lien index to a Notice of Lien Index. This change has been implemented. Stevens is a county of 38,000 people. The IRS has placed liens on properties that would affect the lives of at least 19% of county residents. The largest business in the world today, the IRS, makes Microsoft look like a lemonade stand. The largest fiscal activity in the world today is the pillage and plunder of the American people, Shaver explained to his commissioners. Shaver went on to explain how the IRS, an agency that has been proven to be illegal, unconstitutional, and 89, learned to play the game. 1. Failure to file and taxes owed. Filing any document with the IRS is a voluntary act that overrides your Fifth Amendment, which incessantly terrorizes innocent people in a manner that is totally lawless and discompassionate, has transferred all liability for his illegal property seizures over to county governments across the country. The liability has been placed particularly upon the shoulders of the county auditor and the sheriff because the liens constitute unprosecuted securities frauds, according to Shaver. Shaver, who has been studying the IRS use of this mechanism since the early 1990s, explained how the federal collection agency, the IRS, uses the ignorance of county officials to create a seemingly negotiable instrument out of thin air. The IRS uses the county to obey a state statute, RCW 60.68, that compels a county auditor to file a notice of lien in an alphabetical tax lien list. The IRS will contact the county auditor and direct him to add a name to the county's lien index. Once an alleged lien has been added to the lien index, the next day the IRS agent can come in and say, "Give me a certified copy of the lien index." Then he has proof of a spendable instrument. Go out and pillage and plunder property, explained Shaver. According to Shaver, such an arrangement constitutes a securities fraud. The IRS is guilty of nothing because all it did was secure a certified copy of something that was obviously accomplished by the county auditor under state law when the lien was recorded, probably with a phone call. From the certified copy of the lien index, the IRS then creates a fraudulently derived notice of levy that is presented to the local sheriff. The local sheriff is then told to seize the people's property, and the sheriff then, dutifully, seizes the property and arranges to put the property up for auction. What the sheriff doesn't realize is that he is working from a notice. He is working from an unperfected instrument. He is working from a securities fraud, Shaver said. Shaver is committed to shutting the fraud down. To prove to the county commissioners that IRS tactics are indeed born in fraud, he explained how county officials should address IRS agents. "Okay, Mr. IRS agent, in the past you have induced us into fraud that we won't be a part of anymore. Now first we'll need your delegation of authority from the Secretary of the Treasury of the United States of America to perform the assessment in the first place. Then we want your affidavit, signed and true, correct, and complete, under penalties of perjury, that this person owes something, and whatever that amount might be." I don't think that they will be around because the whole clearing the slate. Affidavit of Foreign Status. This affidavit of foreign status is a public notice to all interested parties concerning the affiant's birthrights and his status as an American inhabitant, as that status would apply with respect to the American states, the 50 independent states of the Union, and respect to the United States as follows. 1. The undersigned affiant was naturally born as a free, sovereign and affiant state of birth, which is one of the sovereign states of the Union of several states joined together comprising the confederation known as the United States of America. 2. The affiant is, therefore, A non-resident alien individual residing in United States which entity obtains its exclusive legislative authority and jurisdiction from Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution for the United States of America. 3. The affiant's parents were sovereigns also, born in sovereign states of the Union. 4. As the progeny of sovereign people, the affiant was born, one of the sovereign people, a constituent member of the sovereignty synonymous with the people. Scott v. Sanford, 1904. 5. The affiant is alien to a so-called 14th Amendment, United States citizen and non-resident to so-called I-4th. 16. The presumption of innocence. Amendment state residency, and therefore, he is a non-resident alien with respect to both 6, as a sovereign whose citizenship originated in affiant state of birth, by birth, and who has remained intact in affiant state of birth since then. The affiant, also a foreigner alien with respect to the other 49 states of the Union, and with respect to the corporate United States. 7, as a consequence of his birth. The affiant is an American inhabitant. 8. The affiant, to the best of his knowledge and belief, has not entered into any valid agreements of voluntary servitude. 9. The affiant is a non-resident alien with respect to the United States as that term is defined and used within the Internal Revenue Code, IRC, Title 26, United States Code, and Title 27, and the rules and regulations promulgated thereunder as follows. The Internal Revenue Code, Title 26, United States Code, and associated federal regulations clearly and thoroughly make provision for Americans born and living within one of the 5 sovereign states of America, to wit 26 CFR 1.8714 proof of residence of aliens of the federal zone. Rules of evidence. The following rules of evidence shall govern in determining whether or not an alien within the United States, incorporated, has acquired residence therein for purposes of the income tax. Be non-residence presumed. An alien by reason of his alienage is presumed to be a non-resident alien. 10. The affiant was not born or naturalized in the United States. Consequently, he is not a citizen of the United States nor a United States citizen, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C., and or Title 27, and the rules and regulations promulgated thereunder, and therefore he is not subject to the limited, exclusive territorial or political jurisdiction and authority of the United States as defined. The United States is definitive and specific when it defines one of its citizens as follows. 26 CFR 1.11 Income tax on individuals. See who is a citizen. Every person born or naturalized in the United States and subject to its jurisdiction is a citizen. 11. The affiant is not a citizen of the United States nor a United States citizen living abroad, as those phrases are defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 12. The affiant is not a resident alien residing within the geographical boundaries of the United States, as that phrase is defined and used within the Internal Revenue Code, 26 U.S.C. and or Title 27, and the rules and regulations promulgated thereunder. 13. The affiant is not a United States person, domestic corporation, estate, trust, fiduciary, or partnership, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C., and or Title 27, and the rules and regulations promulgated thereunder. 14. The affiant is not an officer, employee, or elected official of the United States, or state, or of any political subdivision thereof, nor of the District of Columbia, nor of any agency or instrumentality of one or more of the foregoing, nor an officer of a United States corporation, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 15. The affiant receives no income with respect to employment from any sources within the territorial jurisdiction of the United States and does not have an office or other fixed place of business within the United States from which the affiant derives any income of wages as such, as those terms and phrases are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 16. The affiant has never engaged in the conduct of a rade or business within the United States, nor does the affiant receive any income or other remuneration effectively connected with the conduct of a trade or business within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 17. The affiant receives no income, wages, self-employment income, or other remuneration from sources within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or thereunder, Title 27, and the rules and regulations promulgated. 18. All remuneration paid to the affiant is for services rendered outside, without, the exclusive territorial, political, and legislative jurisdiction and authority of the United States. 19. The affiant has never had an office or place of business within the United States, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulation promulgated thereunder. 20. The affiant has never been a United States employee, nor employer, nor employee, which also includes, but is not limited to, an employee and/or employer for a United States household and/or agricultural activity, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 21. The affiant has never been involved in any commerce within the territorial jurisdiction of the United States, which also includes, but is not limited to, alcohol, tobacco, and firearms, and Title 16, Subtitle D, any excises and privileged occupations, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 27, and the rules and regulations promulgated thereunder. 22. The affiant has never been a United States withholding agent, as those terms are defined and used within the Internal Revenue Code, 26 U.S.C. and/or Title 75. (27) And the rules and regulations promulgated thereunder. 23. The affiant has no liability for any type, kind, or class of federal income tax in past years, and is entitled to a full and complete refund of any amounts withheld, because any liability asserted and amounts withheld were premised upon a or mistake or facts regarding the affiant status. 24. The affiant has never knowingly, intentionally, and voluntarily changed his citizenship status, nor has he ever knowingly, intentionally, and voluntarily elected to be treated as a resident of the United States. 25. The affiant, to the best of his current knowledge, owes no tax of any type, class, or kind to the United States, as those terms are defined.
Debt validation. Collection agencies. Debt validation, the ultimate weapon against the about it, in one of three ways. If a collection account comes into your life, you've heard 1. It came up as a listing on your credit report, or 2. You received a telephone call from a collection agency, 3. You got a letter in the mail. You could try to settle the debt with the collection agency, but you might want to try debt validation first. The best defense against debt collectors is often debt validation. Why? Because the collection agency may not even be legally entitled to collect the debt from you, Joe. Bob, and money borrowed. Let's say you borrowed money from your friend Joe. Joe would be the creditor of this debt, the original creditor. And, let's say time has gone by and you think you might still owe Joe money, although you're not sure how much. One day, a guy named Bob comes up to you and says that he is collecting the money that you owe Joe. Bob is acting just like a collection agency for a credit card company would act. Think about it. Having never met Bob before, would you just hand over your cash to him? No. Or at least I hope you would not. You should have these questions in mind to ask Bob. What legal document exists to prove that Bob is legally authorized to collect money for Joe? How much is the actual debt? What payments have already been made on the account? Where is the accounting of the debt, including all interest and fees? Are these fees and interest amounts legitimate? Do I really owe Joe the money? You remember borrowing money from your friend Sam. At the same time, you remember paying one of them back the next day. Is this the debt you borrowed from Sam or from Joe? Where is the contract showing the terms of the loan with Joe and the contract with Sam? At the very minimum, you should phone Joe or Sam to ask about the loan. You should have the same thoughts about a collection agency who sends you a bill for a debt you that may or may not owe. Don't panic if you receive a phone call or a letter from a collection agency. Your first reaction may be to panic. Calm down and think about the situation. Ignore all of the fancy language and legal terms that the collection agency uses to collect. Think of what questions you would ask Bob in our example. If you do, you'll know exactly what to ask a collection agency. Bob, in our example, to validate an alleged debt. The Fair Debt Collection Practices Act. Debt validation is a legal procedure which is spelled out by the Fair Debt Collection Practices Act, or FDCPA. It matters if the alleged claim is from the original creditor, Joe, or collection agency, Bob. The FDCPA does not cover collection tactics used by original creditors, like credit card companies who issue credit cards. It only governs the actions of debt collectors, collection agencies. Let's look at the definition of these two groups as defined by the Fair Debt Collection Practices Act, FDCPA, Title 8, Debt Collection Practices, Section 803, Definitions 15 U.S.C. 1692 Al. 4. The term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person that receives an assignment or transfer of a debt that is in default solely for the purpose of facilitating collection of such debt for another. This means that, as far as the FDCPA is concerned, a creditor is the original entity which loaned money to a consumer. The collection agency is not the creditor. The definition of a debt collector is as follows. 6. The term debt collector means any person who uses any instrumentality of interstate commerce or the mails in any business the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another. So when a collection agency is assigned, or has purchased, your debt, they are not the creditor, they are the debt collector, and the actions they take are all governed by the FDCPA. What if the person asking you for the money, Bob, is a lawyer? Under the FDCPA, even if Joe hires a law firm or lawyer to collect a debt from you, the law firm of lawyer is still considered a collector and must adhere to the FDCPA. What does a debt collector need to provide as debt validation? 1. Prove that the collection company owns the debt or has been assigned the debt. Bob is legally entitled to collect a debt he owns or has been assigned from you. This is basic contract law. It is very difficult to get a judgment without a direct contract between collection agency and the original creditor. 2. At a minimum, some account statements from the original creditor. You can pin them down on the amount of the debt by requiring complete payment history, starting with the original creditor. How did Bob calculate this alleged debt? What fees interest has Bob tacked on, and how he determined these amounts? This requirement was established by the case, Fields v. Wilbur Law Firm, USCA, 02, C. 0072, 7th Circuit Court, September 2004. 3. Copy of the original wet ink signed loan agreement or credit card application. Your contract with Joe establishing the debt between him and you. Account statements from the original date can fulfill these requirements. What does Bob gets out of the deal? It used to be, in most cases, that creditors assigned, not sold, its debts to a collection agency, but not anymore. Creditors hire collection companies, like Bob, to collect debts for them, because they simply don't have the time or resources to chase down all of their severely overdue accounts. Collection agencies maintain cheap labor and a streamlined system to pursue such accounts. When a creditor hires a collection agency, the debt has been assigned to the collection agency. If a collection agency is successful at collecting the money on the account, they usually keep a percentage of what is collected as payment for services. Original creditors sometimes sell debts in large portfolios to collection agencies. This is starting to be the norm, and several of these companies, called junk debt buyers, JDBs, are now being traded on Wall Street. The companies do not spend much money for these debts, sometimes paying less than 1 cent on the dollar. Even if the debt is not a large debt, they often hire attorneys to send out mass form letters to debtors in the hopes of collecting. As you can see, even if they get a small percentage of the debtors to pay, profits can be enormous. Assigned or purchased debt. How do you know Bob is the right guy to pay? Why should you care if a debt is purchased or assigned? In an assignment, the collection agency does not own the debt, and therefore you do not technically owe them any money. There is no way for a collection agency to prove that you owe them money because there is only an assignment of the debt and not a contract between you and the creditor. One loophole. Some contracts have the wording debtor agrees to be responsible for payment of this debt to creditor or its assigns. This is a contract between you and the debt collector as well as the creditor, and if they can provide you with a copy of a contract that states this, with your wet ink signature, you are pretty much stuck and need to negotiate the debt. What if the collection agency, Bob, proves they purchased the debt? Is he now the original creditor and no longer subject to the FDCPA? If they do purchase the debt, this does not make them the original creditor. They are still a debt collector covered by the FDCPA. Continue to treat any collection agency, junk debt buyer or law firm who says they own the debt as a collection agency subject to the FDCPA. You can still request validation and proof of the purchase, because if they can't validate it, the collection agency can't prove you owe the debt. Often a JDB will lie telling a consumer that since they purchased the debt, they are not subject to the FDCPA. This simply not true. The right to validate your debt under the FDCPA, you are allowed to validate this debt, and the creditor, in this case, the collection agency, must show you proof that you owe the debt to the collection agency, not to the original creditor. Section 809. Validation of debts. 15 U.S.C. 1692 G. B. If the consumer notifies the debt collector in writing within the 30-day period described in subsection A, that the debt, or any portion thereof, is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debtor, or any disputed portion thereof, until the debt collector obtains verification of the debt or any copy of a judgment, or the name and address of the original creditor, and a copy of such verification or judgment, or name and address of the original creditor, is mailed to the consumer by the debt collector. They also must show positive proof that you owe them this debt. It's not enough to send you a computer-generated printout of the debt. So, if a creditor can't validate a debt, they are not allowed to collect the debt, they are not allowed to contact you about the debt, and they are not allowed to report it under the Fair Credit Reporting Act, FCRA. Doing so is a violation of the FCRA, and the FCRA states that you can sue for $1,000 in damages for any violation of the Act. An opinion letter of the FTC clearly spells out that a collection agency cannot report a debt to the credit bureaus which has not been validated. http www.ftc.gov statutes pa letters cas htm. The opinion letter also states that you can sue in federal or state court. So if you have them on a violation, then you have damages of $1,000 for the incident plus damages. Small claims court. Anyone? What to do if a collection
7. IRS levies and liens. Written by Rico S. Giron, future sheriff of San Manuel County, New Mexico. http://ricoforsheriff.com. The Federal Reserve Bank, aka the IRS, is the biggest lie and scam in world history. IRS are the three most frightening and loathed letters in the English language. This deep-seated fear and loathing serves a very specific purpose. It serves to keep the people of America enslaved in submission to an illusion a lie. It is an emotional and psychological chain around the neck of the American people. The IRS has a horrible reputation and has earned every bit of it. It has, by their own admissions, committed crimes against innocent citizens and continues to be the Gestapo of America today. They confiscate more homes, destroy more families, take more money, ruin more lives, and commit more crimes than all the street gangs combined. They are indeed vivid proof that the greatest threat we face as a nation is our own federal government. From The County Sheriff, America's Last Hope, by author Richard Mack. Here it is in a nutshell. The IRS is a private debt collection agency for the private banking system known as the Federal Reserve Bank. 107. Learn to play the game. The IRS is not a government agency. I repeat, the IRS is not a government agency. Never has been, never will be. The IRS, formerly the Bureau of Internal Revenue, BIR, situated in, and with authority only in, the Philippine Islands, Trust Fund Number 61, later moved into Puerto Rico, Trust Fund Number 62, as well. In the 1950s, with the stroke of the pen, the BIR was transformed into the current, notorious IRS and brought onto the 50 United States. This was done without any congressional authority whatsoever. There is no congressional authority for the IRS to exist and operate in the 50 states of the Union recorded anywhere in any law books. Again, keep in mind that the IRS is the private debt collection agency for the private banking system known as the Federal Reserve Banks. Due to the naive ignorance of the American people, most Americans do not realize that there are two titles. 26. Title 26, Internal Revenue Code, is the debt collection manual for the IRS. This manual has nothing to do with constitutional rights. The IRS does not collect an income tax. The IRS is simply collecting a user fee payable to the Federal Reserve Bank because we Americans are using this private credit system. The user fee had to be disguised as an income tax to fool the American people and keep them enslaved. Title 26, United States Code, is non-positive law, which means that no American citizen is subject to it. However, all U.S. citizens are subject to it. In order to understand U.S. citizen, you must go to 28 U.S.C. Section 3002, squared. Camaricalo applied. Most American citizens have perhaps unknowingly, but voluntarily, surrendered their sovereignty in exchange toward the immunities and privileges of the 14th Amendment. There are literally hundreds of silent, unilateral contracts by which American citizens declare themselves to be U.S. citizens and thus subject to both Titles 26. By voluntarily becoming a U.S. citizen, every American citizen declares him herself to be an indentured servant, a slave to the non-federal, Federal Reserve banking system with no constitutional rights whatsoever. So then, Title 26, USC is a private law that applies only to U.S. corporate citizens, who are all employees of the corporate entity identified at 28 U.S.C. Section 3002-15. ABC as the United States. 15 United States means A federal corporation, B an agency, department, commission, board, or other entity of the United States, or C an instrumentality of the United States. Consider this fact. When an IRS agent wants to seize property from a citizen in a county, they must first contact the sheriff of the county and request assistance in the seizure, because the IRS agent has no authority to seize any property at all. So the IRS agent bamboozles the sheriff into committing the crime for the IRS. When the sheriff seizes property from a citizen under the non-authority of the IRS agent, the sheriff has committed a second-degree felony, conversion of property. 10. Seven. IRS levies and liens. Written by Rico S. Giron. A second-degree felony is incredibly serious. However, both the IRS agent and the sheriff, knowingly or unknowingly, count on the ignorance of the citizen who has no idea what their lawful rights are. Bear this point in mind. If the IRS agent has no authority to seize any property at all, then they cannot delegate or confer on the sheriff what they do not have. In addition, the sheriff has no idea that he has engaged in a serious crime. Here is where the maxim, ignorance of the law is no excuse for violating the law, applies. Hence the maxim, the law leaves the wrongdoer where it finds him. We do not have an excuse based on the legal system. Both the IRS agent and the sheriff should be arrested and charged with conversion of property, a second-degree felony. Tyranny is defined as dominance through threat of punishment and violence, oppressive rule, abusive government, cruelty, and injustice. What better definition than this fits the abusive IRS? America is using a private credit system wherein the medium of exchange is the Federal Reserve notes that we call dollars. Hence, the so-called income tax is in reality nothing more than a disguised user fee that Americans must pay to the non-federal Federal Reserve Bank for using their private credit system. Research Title 12, USC. The legal definition of dollar is a gold or silver coin of a specific weight and with specific markings. Thus, a Federal Reserve note, FRN, is not and cannot ever be a future sheriff of San Manuel County, New Mexico. The IRS is not a government agency. I repeat, dollar. A note is not money. See Black's Law Dictionary. The Federal Reserve notes in use today are mere evidence of a debt. I repeat for emphasis, Federal Reserve notes are not dollars and can never be dollars. The Federal Reserve banking system is not a federal government agency. There aren't reserves, and there is no real money of account of the United States in existence and used today. The Federal Reserve banking system is a private cartel that has usurped the authority of the Congress to coin money. Federal Reserve notes are just as worthless or just as valuable as monopoly money used in the game Monopoly. If we go to the Constitution for the United States of America, Article 1, Section 8, we find that only Congress was given the authority to coin money, regulate the value thereof, in a foreign coin, and fix the standard weights and measures. This authority given to Congress by the Constitution for the United States of America was not to be delegated to any private corporation for that corporation's private gain. The authority to coin money was usurped by the unlawful enactment of the Federal Reserve Act of 1913. The Federal Reserve Act is a private law passed by only 4 congressmen after the congressional session had closed for the Christmas holiday in December of 1913. Congress can pass both private laws and public laws. Congress does not have to tell the American citizens which law is private and which law is public. We are simply led to believe that all laws are public. This is propaganda and brainwashing at its best. Starting from 1913, we Americans voluntarily submitted to this private law through our own ignorance. Once we submitted to this private contract law, we became voluntary slaves of the Federal Reserve System. This was a silent coup d'etat wherein the American people became the slaves of the Federal Reserve Bank. The killing blow, the coup de grace pronounced de grace, was delivered upon the American people by Franklin D. Roosevelt in 1933 by removing the gold standard from the American economy. Franklin Roosevelt assisted the FRB in heisting the gold supply from this country right out from under our noses. The Federal Reserve Bank is the single largest in operation ever set in motion. FDR knew what he was doing. Since then, no American citizen has actually paid for anything. We have just exchanged worthless Federal Reserve notes for more worthless Federal Reserve notes. We lease our property from the state of your state. We lease our cars. We lease our houses. We own nothing. Since 1933, no American has owned their property in allodium. That is why the state of your state can take your property for just about any reason. That is eminent domain, failure to pay so-called property taxes, state income tax, etc. For anyone who has ever dealt with a debt collection agency, you know how nasty, mean, and dirty they can be. Now take that nastiness, that meanness and dirtiness and IRS strategy. Scam. Here is how it works. The IRS operates a clearly defined and very clever. 1. The IRS presumes a fictional, fraudulent, nebulous, libelous, and imaginary assessment against a citizen. 2. The IRS presents this assessment as a notice of tax lien to the county recorder. 3. A notice of tax lien is supposed to instruct the tax Debtor as to where the actual tax lien can be found, studied, and copied so that it can be challenged if necessary. But the notice of tax lien never does provide that information, because the IRS never produces any tax liens to which a notice could refer. 4. An unlawful statute injected into the Revised Code of Washington at RCW 60.68.045 by the IRS, and uncritically allowed to reside there by legislators, other officers of the government, and citizens, direct the county recorder to enter the notice of tax lien on a tax lien index. 5. But a notice of tax lien does not contain a sworn affidavit assessment and is therefore only a non-negotiable, non-spendable paper instrument, which means that it cannot be used as money after maturing unchallenged in 90 days to procure, seize, sell property. 6. And a lien, any lien, if lawfully constructed, must contain a sworn by affidavit assessment as part of the full disclosure requirement of all negotiable instruments and is therefore a negotiable spendable paper instrument, which means that it can be used as money after maturing unchallenged for 90 days to procure, seize, and sell property. 7. Since the IRS never presents a tax lien to the county recorder, because IRS agents do not want the liability for presenting a false, fraudulent, nebulous, and/or libelous assessment, it must procure or suborn the county recorder to do IRS counterfeiting for it by counterfeiting the appearance of the existence of a tax lien, by changing the title from a notice into a lien by unlawfully entering it on the wrong index, a tax lien index. 8. By changing the title from a notice into a lien, the county recorder has converted a non-negotiable, non-spendable paper into a negotiable, spendable ledger entry, and has therefore counterfeited a currency for the IRS, lacking full disclosure. 9. Then, all the IRS has to do is to ask the county recorder for a certified copy of the tax lien index to prove that a lien has been filed. This certified copy of the tax lien index has the same power in commerce as a Federal Reserve note, because it can be used as money to procure, seize, and sell property, to transfer property from the citizens to the IRS. 10. Once the IRS has the certified copy of the tax lien index implying the filing of a lien, the IRS can begin taking wages, bank accounts, investments, Social Security payments, retirement benefits, houses, cars, and just about anything else that will bring cash to the IRS directly or by auction. 41. The public, the legal establishment, and the courts are all conditioned by threats of IRS retaliation to do whatever the IRS dictates, so the scam is complete. Therefore, there is no remedy through the judicial courts. The only remedy of this problem is to ignore the judicial system and to use the same ancient and timeless system of commerce which the IRS uses, but to use the commercial system lawfully and properly by doing everything with sworn affidavits containing full disclosure. Acts chapter 20 verse 16. Certified to be the truth, the whole truth, and nothing but the truth. By Hartford Van Dyke, a non-union non-bar association lawyer, not an attorney.